The concept that water is sacred, even though we may not understand the linguistic or the cultural connotations of water. But if you are able to understand the concept of wai, it means to ensure that this body of water, this liquid, becomes infused with and retains the ha that's being breathed over it through the pule.
But the issue was who owned water. The court announced that the water was not owned by anybody except the state. That these parties who were claiming it was theirs had gotten it wrong, that it was really belonging to the state. The term state ownership. He also declared that the waters could not be removed from the valleys. So the decision was attacked as a taking of the private property of the sugar companies who came before the court. Before the decision, they had the water as private property. After the decision, they didn't. Water was a thing.
So this is grounded in ancient Hawaiian custom, but also in the very first laws of the Hawaiian kingdom, of the sovereign Hawaiian kingdom. And then they pivoted to this statement. We believe that the right to water is one of the most important usufruct of lands. Usufruct is a fancy legal term for use or the ability to use something. Usufruct of lands, and it appears clear to us that by the foregoing limitation, the right to water was specifically and definitely reserved for the people of Hawaii for their common good in all of the land grants. Therefore, the right to water was not intended to be, could not be, and was not transferred to the awardee, and the ownership of water in natural watercourses, streams, and rivers remained in the people of Hawaii for their common good. So says the Hawaii Supreme Court.
That is amazing.
Well, up until the overthrow. After the overthrow, the court had changed. People in the court were part of the revolution, the overthrow. They were also, the court was dominated by sugar lawyers, and the situation was sugar was king, and the big five ruled Hawaii. And so the sugar companies began to influence the law to create this ownership of water. So the social revolution by which CJ became Chief Justice had a lot to do with the fact that the court overturned the years of ownership of water. And if you want to look at footnote 25, I think that's very poetic, and I think Justice Pollock admires it. It speaks to the four regimes in which there's law in Hawaii, and that the law from the territorial period came from a period when Hawaii did not have self-governance. The governor was appointed by the president. People didn't elect the governor. The president appointed the justices. That changed the statehood. The governor would appoint the justices, and he was the person that now, because of the change in political way we selected the governor, he represented the people much more than before.
Because the plantations take the state of Hawaii to federal court alleging an unconstitutional taking of their property and water. It goes to the Ninth Circuit. The Ninth Circuit certifies some questions to the Hawaii Supreme Court. Tell us more about what you're thinking about this thing. And so there's this footnote dropped in the middle of that. And they say, you know, all this previous law about water being private property was during the territorial period when the judiciary was not a product of local sovereignty. Okay? And then he goes on to say, and this was authored by CJ Richardson, this Robinson opinion. It took place during a period when the resources of our land were subject to an authority which did not directly represent Hawaii's people, and that the most recent pronouncements on the subject, that is the Richardson Court, arise more immediately from the authority of those who will forever be affected by it. I mean, how boss is that? When I read this thing, and really, so it's a statement of the Hawaiian word ea. It's in our motto, ika, wamau ke ea ika aina. And this was about ke ea o kawai. And yeah, so it really was CJ's real move to decolonize water law unholy.
That's great.
He was almost, I think he knew what was coming, but he couldn't do it all in this opinion. And he distinguishes what I call the Western public trust doctrine, which is essentially protection of navigable waters, where it's a restraint sort of on the sovereign powers to protect navigable waters. And what he said, I think the exact word was, it was akin. Our public trust doctrine from the kingdom was akin to the Western public trust doctrine, but not the same thing. And the difference is the king had reserved the water for the people. So the focus of the public trust doctrine was on the people and reserving it for the people, and not merely restraining the sovereign. And that led to what came after.
Holy Ditch combined contested case hearing. The Supreme Court issued its decision in 2000. Justice Nakayama authored that opinion, and it combined all those elements, constitution, statute, all the way down into what people recognize as a leading case on the public trust doctrine, not just in the U.S. but in the world. Joe Sachs, the godfather of the public trust doctrine, coined the term the public trust trilogy, which includes the Illinois Central case, the original U.S. Supreme Court case protecting navigable waters, the National Audubon case from the California Supreme Court protecting Mono Lake, and then our own Waihole Ditch case. So that was in 2000. Now we're 25 years later, and to your question, have things changed? I think that public trust is an accepted and settled part of our legal landscape. Everyone knows what it is. Everyone speaks that language, thinks in those terms. And then you have something like the disaster in Maui last year, where just in a finger snap, it all wasn't unraveled, right? Ultimately, society in general, but the law as well, is so fragile. And democracy can really evaporate, in an instant if we're not vigilant.
The agency has to take the initiative to consider, protect, and advance public rights. Decisions must be made with openness, diligence, and foresight. There's a duty to preserve and protect public trust resources whenever feasible. An agency has to consider a cumulative impact of the proposed use and also consider alternatives. It places the burden of proof on the applicant to show that the use won't interfere with public trust purpose. Higher level of scrutiny applied when the proposed use is commercial or private. The agency has to mitigate harm. If there's going to be harm to the resource, presumption in favor of public use, high level of scrutiny, and findings of facts that has to track what the agency did. That's all out of that case. Because the advantage of the public trust being held to protect these particular resources is we get this framework. And that means we're going to get more reliable decisions. So that's one thing. I believe that the public trust, so those of you with students, when you're going out to litigate, think of all the other things that we can protect. The forest, all our forests, there's no specific public trust protection that I can find. We have zimmering that protects lava, and we have only conservation land. So I don't see the constitutional provision saying land, only certain land. Nor do I see in the constitutional provision that we're going to have different frameworks. So in the second TMT case, I argued, look, we need to have a framework for everything else but water, because if we don't, we're leaving it up to the agencies to decide how they are going to apply the public trust doctrine. There's no specific principles other than in water. So those are things that I'm looking forward to, because I think we're just in the evolution of the full application of the public trust doctrine. And the more it is applied, the more future generations will have those resources protected for them.
So that's the reality of, get plenty more stops in line at that Is it the ugliness of what we're going through now? We're just trying to survive and get our people together and make sure everything, let him know that everything will be okay. Look at our pots filling up with homeless. You know, get some people slip through the cracks and that FEMA cannot help. And they ending up at our parks, sleeping outside.
We're struggling to even exist in our own community today. And so if we're gonna talk about this glorious rebuild and all of that, it's gonna, now that we said, it's gonna start with the people, but how much of a position do our people have to even say how things are gonna happen if we have nothing? We have nothing. And so, give us the water.